the session coordinator for this morning session. Thank you.
Thank you very much, my namesake, Adewale. Good morning, everyone. My name is Dhikrullah Adewale Balogun, and I welcome you all this beautiful morning to this wonderful session, a session that deals with the immunity of arbitrators. And without much ado, but permit me before I bring on my panelists, let's please appreciate the sponsor of this session, Stephenson at Harwood. Please, let's appreciate them by putting our hands together for them. They have permit me to bring on to the podium this wonderful session. Please join me to welcome Daniel Wilmot. And after him, I will welcome onto the stage Perenami Momodu. In the same vein, let me welcome Mr. Shola Ephraim Oluwanuga, MNI. And then my wonderful moderator for this session is no other person than Aisha Abdullah from Kenya. Without much ado, I'll hand over the stage to Aisha to take the stage. Thank you.
Good morning, everyone. Morning, and happy Friday, Juma Mubarak. I hope you're all excited about this topic. I do feel that some of the thunder was stolen yesterday in guerrilla tactics, but we will still try and give you more tactics to use. So today we're talking about arbitrator immunity because Section 13(1) of the Arbitration and Mediation Act in Nigeria provides limited arbitrator immunity except for bad faith. However, we are seeing, I believe from my colleagues' experience, that allegations of breaches of fair hearing under Article 46(1) of the Constitution are being used to delay arbitration proceedings and essentially to mount a collateral attack on the arbitration. And we wanted to just start with a poll of the audience about whether we think that arbitrators should have immunity, absolute, conditional, or none at all. So first, if we could project the poll, please. So there's a poll on Slido, and we'd ask you to vote on which of the three options you think arbitrators should have in terms of immunity. And then we're going to run the poll again at the end of the session to see if any of my panelists have managed to convince you to change your mind. So I believe almost everyone is agreed that conditional immunity is appropriate for arbitrators rather than absolute or none. Thank you.
A very interesting topic. Lexicon for the first time in Nigeria. It has been said in a particular case, Shifban, that courts and arbitrators are in the same business, namely administration of justice. And it was then argued that since judges enjoy immunity, arbitrators should be immune from liabilities that might arise from the performance of their duties. And so in Nigeria, even though there had been some moves, particularly the Lagos Court of Arbitration, LASEAC, Delta State, Port Harcourt, in their arbitration documents, they had a certain level of qualified immunity. But then it took the Arbitration and Conciliation Act, then Arbitration and Conciliation Act, some time to arrive at that juncture. The AMA 2023 then brought into full glare arbitration immunity in Nigeria. So what's the scope? What is immunity, by the way? Immunity in arbitration refers to the protection afforded arbitrators, mediators, and other participants in ADR process from liability for their actions. There are types of immunity, as we have seen, the absolute, qualified, and functional immunity. Under the AMA, there is a certain level of immunity. It is not absolute. The AMA section 13 says an arbitrator appointing authority or arbitral institution is not liable for anything done or omitted in discharge or purported discharge of their functions unless the action or omission is shown to have been done in bad faith. So bad faith is the key. And then the question then is, what is bad faith? There has been no definition of bad faith in the Act. And so we resorted to the Black's Law. And the Black's Law, as is to say, the opposite of bad faith is the opposite of good faith, generally implying or involving actual or constructive fraud or design to mislead or deceive another, neglect or refusal to fulfill some contractual obligations. You would ask, why immunity? Why do arbitrators need protection? What's the rationale for immunity? One, immunity would allow the arbitrators, would encourage impartiality. Immunity ensures arbitrators make decisions without fear of personal liability. You're free. You have a free man to go into the reference, make your decisions because you are not bogged down. Professional independence. It shields arbitrators from external pressures and influences. It promotes efficiency, reduce delay or cost associated with frivolous lawsuits. Again, immunity would allow for courage to make decisions without fear of personal repercussions, preserves integrity of the process by preventing parties from harassing arbitrators on unfounded claims. But keep in mind, while some said there must be immunity, others would say there should be no immunity. Why? You can't just give people a free lunch. There are so many people coming into arbitrations today because they think, oh, that is the way to go. There's a lot of money to be made. And so there should be no immunity. But then Nigeria has followed the best practice that there should be qualified immunity in arbitration. I'm sure later we're going to look at the types of bad faith. But quickly, let me just mention that bad faith can come in different forms. It can be procedural bad faith. In other words, denial of fair hearing. Someone will be talking about on that later. It can be conduct-related bad faith, substantive bad faith, and of course, other forms of bad faith like ex parte communication. And the consequences of this bad faith is that there'll be a waiver of immunity. There'll be liability. And then again, of course, there might also be disciplinary action. The arbitrator may be, if it's an institutional arbitration, may be reported to the institution. And if not, the arbitrator may be reported to the body that, like for instance, a lawyer, as lawyers, arbitrator will be reported to the appropriate disciplinary committee, of the legal profession. So that is my own intervention for now, as it concerns the scope and extent. Thank you.
Thank you, Shola. Perenami, can you maybe add anything to the scope?
Absolutely. I'm happy to add my voice to this. Thank you very much, Aisha. Mr. Oluwanoga has hit the nail on the head. He's given us, the rationale for this inclusion in the new AMA. But I wanted to say, there's a saying that in a war, you don't shoot the messenger. But what we've seen is that in arbitration, the messengers have been shot many times. And, for me, this is one of the reasons why this inclusion of Section 13 in the AMA was very necessary. There have been many actions where arbitrators have been joined, even if it was for anti-arbitration injunctions. There's really no claim against the arbitrator, but they are added in there. Of course, there's some other unscrupulous actions where parties are directly going after the arbitrators. Now, in order to protect our arbitration ecosystem, this immunity provision, of course, needed to be statutorily provided. And I'm very, very, very pleased with this provision. But like many jurisdictions, this bad faith exemption has not been defined in our laws, and there is obviously an opportunity for abuse. We know that under the old Arbitration Act, there was the term misconduct, and many arbitration users had abused the term misconduct, packaged many cases, packaged many challenges alleging misconduct of the arbitrator. This has now been taken out. What we have now is bad faith as an exception to immunity, but of course it's bad faith not in terms of challenge, in terms of the immunity. But, one can't help but wonder if parties are still not going to go about, a roundabout way or a backdoor way of trying to challenge an award or even halting the proceedings by packaging any little action as an act of bad faith. It's a new provision in our law. We're hopeful and to see how this bad faith provision will be interpreted and, what the future really holds for us as an arbitration community.
Thank you, Paranami. Daniel, can you give us a comparative perspective from Europe and the UK?
You cannot hear me. Can you hear me now? You can. Very good. Thank you, Aisha. Thank you to the organizers for inviting me, and it's a real pleasure and honor to share this panel with you all. So thank you. To give you a bit of a comparative view, I think it's worth just taking one step back and understanding the rationale and the way that Shola has introduced it, because I think that then gives an insight into the way different jurisdictions approach the question of immunity of arbitrators. I mean, there are two categories of immunity in a sense. You've got the immunity of arbitrators and you've got the immunity of arbitral institutions. Now, the second category is not what we're here for today, but I think it's interesting just to note that most institutions tend to provide for their immunity in their rules. But that in and of itself raises a question as to how an arbitrator might ever be able to enforce any similar provisions in rules that seek to protect them. And that in turn raises the question of, well, what is the relationship between an arbitrator and a party through a legal prism? Is it contractual? Is it functional? Because of course, for the question of immunity to arise, there needs to be a liability, and that presupposes that there is some sort of relationship between the parties and arbitrator that is enforceable at law. I think that's the starting point for the analysis. Most jurisdictions are silent as to what that relationship is. I think we can all accept in the room that if arbitrators do something wrong, they should somehow be held to account. But quite how that should be affected, is it via the bar rules, ethical rules? Is there some sort of implied contract between the parties and the arbitrator, despite them actually not signing a contract as between them in institutional arbitration, at least, is important. Now, some jurisdictions have taken the approach of assuming there is a contractual relationship, a sui generis, a curious type of contract. That includes mostly civil law jurisdictions. Germany, France, Switzerland are some examples. The alternative approach tends to be the sort of approach that Scholar was describing, which is functional, which is to say the starting point is arbitrators should be treated like judges, and therefore they should be free to rule, arbitrate, adjudicate without worry or concern of reprisal or recourse from the parties. However, I saw quite a few nods in the room that arbitrators shouldn't be given a blank check to do what they want to do. And so whether you take a contractual analysis, which essentially is to say arbitrators provide a service in return for a fee. If the service doesn't meet the standard, then there should be some sort of liability. Or whether you take the functional analysis, which is arbitrators should be treated like judges, but they shouldn't have carte blanche, you probably end up in about the same place, which is to say immunity should be presupposed, but it shouldn't be absolute. But that different starting point is relevant to the question of immunity. I think there are some notable exceptions. The USA pretty much is as close as you can get to absolute immunity. There are examples where no immunity exists at all. And some examples I have there is the People's Republic of China, Japan, interestingly, Vietnam. And I've been asked to talk about the English position. So let me, having set that context, come to England. England takes the functional approach, if I might put it that way. We don't have an assumed contractual analysis between the parties per se. And our question of immunity is now, like Nigeria, regulated in our arbitral law, so the Arbitration Act of '96. And we have a specific section 29, which is mandatory. It cannot be disapplied. And therefore, it applies to any arbitration which falls within the four walls of the Arbitration Act. Broadly speaking, any arbitration with a seat in England, Wales, or Northern Ireland. Sometimes it's referred to as the UK Arbitration Act, and the Scots get very angry when you say that. It's sort of UK without Scotland. There are, in essence, 3 exceptions to absolute immunity under the Arbitration Act, so thus equating to qualified immunity. The first is where an arbitrator conducts an act or omits to act in bad faith. So we're very similar to what is your position as I understand it now. The second, although it is soon to be narrowed, is where an arbitrator resigns, and they resign in unreasonable circumstances and thus cause the parties to suffer a loss or incur a liability. And third, although you won't find it in the Act, is there is now a string of case law where arbitrators have been held liable for the costs of a challenge that a party may bring to remove them at court. So if they are removed, the English courts have on occasion said, well, the costs of that challenge should be borne by the arbitrator, and thus that is an exception, in essence, to immunity. I said things are going to be narrow. That's because hopefully at some point this year, now looking unlikely, our Parliament will pass the arbitration bill, which will modernize, in inverted commas, our '96 Act. We started thinking we're going to modernize it like this, and we've ended up about here, but such is the way. The 2 differentials that this act is going to impose on this context is arbitrator resignation. There will be an assumption that it imposes no liability on the arbitrator unless such resignation is unreasonable. That's now going to be set in stone in the statute. What constitutes unreasonable resignation? No one knows. It's not defined, and of course we haven't really had a case on it. Halliburton and Chubb got close, but it was more obiter dicta and it's by inference. And then the liability for costs on a successful challenge has been removed completely, unless the arbitrator was acting in bad faith, which is the cause of their removal. So we get back to bad faith, which is very similar to where I understand Nigeria now is. What is bad faith? I'll leave that for a later moment on the presentation. Thank you.
Thank you, Daniel. Paranami, I think you had some comments to make about immunity in the UAE or developments outside of Africa.
So just to give a quick comment, between 2016 and 2018, the UAE had an amendment to their penal code in which arbitrators were liable to be criminally prosecuted. And it said arbitrators could be temporarily imprisoned for failing to maintain the requirement of integrity and impartiality in their capacity as an arbitrator. And of course, like I said, this was only enforced between 2016 and 2018. And one of the immediate repercussions of this is many arbitrators immediately resigned. Of course, people were not taking UAE appointments because you just couldn't tell, what could happen. And it certainly would not look pleasant on your CV to say that you had been temporarily imprisoned, even if it was just for one day, because, of some action that happened in your arbitration. So I thought that was a good comparative analysis to add in. Of course, that has been taken out now, thankfully, so we can now accept UAE appointments.
Not all that glitters is gold, I think is what Paranami is actually saying. Yeah. So Paranami, back to you. I was hoping you could give us more examples in Nigeria of what might actually constitute bad faith.
Thank you, Aisha. Well, I'll start by saying, the whole bad faith concept was only introduced last year into our laws. So there's, the case law on this point is really developing. So bad faith could range from failure to disclose, a situation of conflict. It could be assuming jurisdiction when there's none, but I wanted to say that basically in terms of our conduct, and in terms of immunity of arbitrators, it's, parties are at this moment not paying too much attention to that provision of immunity and bad faith, or paying too much attention to the exemption that they can actually challenge an arbitrator on account of bad faith. And my view is that, to be able to challenge an arbitrator on account of bad faith, the threshold should be really high. The evidentiary threshold will be high. The chances of success of such an action will be low. So parties are a bit more looking for more disingenuous means to do this. And one of the trends that we're seeing is fundamental rights enforcement matters. Parties are now, for actions acting during the course of the arbitration, parties are running off to court and filing and claiming that their rights to fair hearing have been breached. Of course, the Constitution guarantees a right to fair hearing. So it is quite bizarre that parties will say, look, I was supposed to file a pleading on the 21st. I asked for an extension. The tribunal only granted me 2 days. So my right to fair hearing has been breached. An interesting case in which some people in the room may be aware of is a matter in which parties had agreed to ICC arbitration. And of course, at the point of your agreement, parties should have been aware or should have been advised of the cost of ICC arbitration. Now, in this matter, the claimant paid its deposit on cost, of course, and the arbitration proceeded. The respondent, on the other hand, filed an elaborate counterclaim, could not pay his deposit on cost, asked for several concessions, was granted here and there, At the end of the day, of course, if you're not able to pay your deposit on cost in terms of your counterclaim, chances are your counterclaim will be deemed withdrawn. And so this party ran off to the court to claim that, its fundamental right had been breached because its right to have its claim determined had been foreclosed. The court, in its wisdom, agreed And what the court did was to set aside all the proceedings in the arbitration, set aside the procedural orders in the arbitration, and granted damages against the claimant in that case for instigating the arbitrators to breach the respondent's right to fair hearing. It's a bizarre decision. It's gone on appeal now, so it's something that we are all monitoring. But the point is, these are the things that we are seeing now. When parties are not focusing exactly on bad faith, challenges on account of breach of fair hearing, fundamental rights enforcement are being filed. And we know that fundamental rights enforcement are pretty easy to file. They have, short timelines. So it's a very easy way for a party to halt arbitration. It's an easy way to get, a backdoor anti-arbitration injunction. Now, in the case that I have described, what is left for the arbitrators to do? Should the arbitrators continue with that matter and risk contempt of court proceedings, or should they hands off? Of course, naturally, nobody wants to be cited for contempt, so they had to hands off. So these are the sorts of actions that we're seeing. And if the arbitration users and the judiciary are not serious about protecting the immunity of arbitrators, we're not going to go anywhere. There's no way we're going to move forward from where we are. If parties cannot challenge arbitrators on account of immunity, they will find other ways to ask for damages. Now, again, imagine in this case that I'd given an example of, if the judge had awarded damages against the arbitrators, I mean, that would be even worse. So I think for now, I'll leave it here for now, and then we can come back to this.
Thank you. Shola, did you want to add anything from Nigeria?
Oh, yes. I think as an umbrella perception, the Nigerian courts, especially the Supreme Court, has given a general covering on the issue of suing the arbitrators. For instance, in NNPC and Fongtai, the Supreme Court held that found at unsubstantiated and spurious challenges against otherwise good awards and arbitration tribunal. So that matter that has gone to the Court of Appeal, maybe one may wish to say that there is hope. Hope is not lost. Now, coming down to particulars of bad faith, you recall that initially I said you could have conduct-related bad faith, for instance, showing favoritism or prejudice towards one party, corruption, receiving or soliciting bribes, engaging in other corrupt practices, fraud, intentionally deceiving or misleading parties, misconduct, engaging in unethical or unprofessional behavior. And then you come to procedural. For instance, failure to disclose relevant information, withholding material facts or evidence, denial of due process, disregarding parties' rights or procedural fairness, ignoring or disregarding applicable laws, and then substantive bad faith, such as manifest disregard for the law, intentionally disregarding applicable laws. And let me say this, even though Nigeria, we hung our immunity on bad faith, in the same act, in the rules, it mentions intentional, that is intentional wrongdoing. And you discover that some organizations in Nigeria use the word intentional wrongdoing. So the question is, what's the difference between bad faith and intentional wrongdoing? From my research, it would appear that bad faith, would cover, the procedural bad faith that we've been talking of, the easy ones. But intentional wrongdoing will be something that is of a higher pedestal, something that the arbitrator really goes out to do the wrongdoing, something that will result in, in damage, is intentional wrongdoing. So essentially, those are some of the issues. And to round up, you have communicating with parties ex parte, receiving unauthorized communication or gifts. In Nigeria, there's a culture that you can always, you are sent, for instance, you are sent a Christmas gift during Christmas. You cannot do that as an arbitrator. You cannot receive gifts, because if you do, that might be said to be bad faith. And who knows, that might be used against you If they can't go against the award, let's go against the arbitrator.
Thank you. As you spoke, Perinami and Shola, it occurred to me that a lot of the examples you are giving of bad faith would actually amount to grounds of challenge under the New York Convention. Because if you have breaches of natural justice, that generally gives you a ground of challenge. So I believe there is this interplay between the immunity, which is challenging the arbitrator personally, but also the grounds of challenge, because often if, you know, the attack on the arbitrator is really a collateral attack on the award. So it seems to me that there is some overlap in some
Sorry,
jurisdictions.
Just a minute, and that's the point. That why not go against the award?
Sometimes you don't get to
You
an
know,
award.
Then that's it. And he says, rather, if I lose the award, I will not lose the arbitrator. So we don't want that to, to occur in Nigeria. And we do hope that we're not giving our litigants, our lawyers, the idea of going after the arbitrators.
So I think the issue is that you may not have an award at the time you are choosing to attack the proceedings, and you wish to delay or attack the proceedings. But I'd like to hear from Daniel. Daniel, do you have any examples of bad faith from the UK you could share?
Ooh, I was worried you were going to ask me that. Just let me put on the record that I don't currently have any mandate sitting as arbitrator, so I'm open to receiving gifts from everyone in the room, just to be very clear. So whilst we might be now in the same territory as Nigeria in terms of having a concept of bad faith in the context of immunity, I think based on my understanding, we then depart from Nigerian historical practice in terms of the number of times that arbitrators have been directly made parties to challenges, or their immunities have been called into question. Because my understanding is, and I see your question, Hamid, as well, which suggests there is something of a trend in this jurisdiction for arbitrators to be legally attacked, let me put it like that. In my jurisdiction, it's completely the contrary. To the extent that when I was looking for cases under Section 29 of our Arbitration Act, whereby the issue of immunity and the meaning of bad faith had been put into question, I couldn't find a single one. Now, when the Arbitration Act in 1996 was passed, of course, there are legislative reports and consultative reports as to Parliament's intention behind its promulgation. And so I looked there to see, well, what did the drafters of this act have in mind when they put in the term bad faith? And in true legislative fashion, they said bad faith must be understood by reference to the concept of bad faith, which is not very helpful. They said everyone knows what bad faith means. No, they don't. And they said the English common law is perfectly able to work out what bad faith is, which it probably is, but we need someone to do it. They did refer to one case, however. Now, bear in mind, the Act was passed in 96. This was a case from 95. So I suspect some junior researcher just found a case that mentioned bad faith and they just referred to it in the report. And this is the definition of bad faith that was given. You tell me if you think it applies in this context. Malice in the sense of personal spite. Now, I don't know how many of you in the room who sit as arbitrators have sort of personal spite against parties, but don't. A desire to injure for improper reason, which suggests you can injure for proper reason, just not improper reason. So please make sure you're absolutely proper when you injure your parties. And then knowledge of the absence of power to make the decision in question. Now that to me sounds like a very standard Section 68 arbitral challenge territory, rather than necessarily hitting the threshold of bad faith, but I can see it's debatable. So I'm not sure how helpful that is, and I'm going to take from a few laughs in the room that you're not sure how helpful that is as well. But that's as close as I could get, I'm afraid. But in case it helps, I had a quick look comparatively as well. In France, the exception to absolute immunity is where there is personal misconduct equivalent to misrepresentation or fraud, gross negligence, or denial of justice. So they've given a bit more meat to that. In Hong Kong, it's dishonesty. That's what they are focusing on. And then I found some case law. What does dishonesty mean? And I'm afraid we got back to bad faith. So we don't get much help there. In Italy, they've been more prescriptive. So if you fail to perform your duties as an arbitrator and you are commit willful misconduct or gross negligence, you will be held liable. An unjustified resignation will give you liability. But interestingly, the burden is on the arbitrator to prove that their resignation was justified. And some examples of justified reasons: health, inaction by the parties, and of course, if the parties fail to pay your fees. And then finally, interestingly, a failure to issue an award at all or on time can amount to an exception to immunity. So if you're busy, don't accept an appointment in Italy, essentially, because you may well find yourself at the hot end of a claim. Thank you, Aisha.
Thank you, Daniel. So now I'm going to invite all the panelists, starting with Perenami, to comment on how in this complex landscape are we going to balance rights to fair hearing and prevention of misconduct with safeguarding the private, confidential arbitration process from undue interference by the courts. What mechanisms can we use?
Thank you. We've already identified here that some of these challenges and allegations of fair hearing and, however way a party may challenge an arbitration are collateral attacks on the award itself. Now, having said that, we should look at it, for me, the way I see it is from two angles. At what stage does this come in? Does it come in during the arbitral process? Now, if a party is alleging that there's some breach of fair hearing during the arbitration, I don't believe the courts should interfere with that. In the same manner in which the tribunal can rule on its own jurisdiction, the tribunal can also rule on whether there has been fair hearing or not. Now, if you take it to the post-award stage, if truly the perceived lack of fair hearing exists, this is a ground to refuse recognition under the New York Convention or under 68 of the Arbitration and Mediation Act. So to me, it's frivolous to allege fair hearing and then run to courts to have the court to set it aside. The court should not interfere. The law is clear as to the extent of the court intervention in arbitration. And so we shouldn't be imputing extraneous things into the law. If the law already says this is the way that the court should interfere, they should not interfere. If there's a breach of fair hearing, parties know exactly where to go in terms of that breach. Now, I also wanted to add that if a party files an action and there has been no allegation of bad faith, of course, it's joined the arbitrator or the tribunal or, the arbitral institution to this action. If there has been no allegation of bad faith, the first thing the court should do in this instance is strike off the names. And I say this because there are many anti-arbitration injunctions that are filed, and there's actually no direct relief. There's no claim against these people. They've just listed on the process. So the first thing they should do is strike off the names, and as we already know, if an injunction is granted, it's not really directed at the tribunal. It really should be directed against the parties. It's not the tribunal, so strike off the names. Now, the second point I wanted to make is if a party does file an action under Section 13 of the AMA and alleges bad faith, the threshold should be super high and punitive costs, substantive costs should be granted if that application is not favorable. Now, as a last point, I wanted to say that also perhaps arbitrators and the institutions should consider professional liability insurance. Now, this is because there will be many of these actions that will be filed. I will not expect, if I were sitting as an arbitrator, it certainly will not be fair to be having counsel on record if I choose to appear in that matter, or even if it's to watch brief or observe proceedings, or damages may be awarded. So you should have some sort of professional liability insurance in the unlikely event that happens. So those are my suggestions, Aisha.
Thank you. Daniel, any suggestions on this topic?
Excuse me. For those who follow the exploits of Nigerian parties in front of the English courts, you'll know that arbitrators doing bad things is something that's particularly close to my heart after a judgment in August of this year. I struggle with the idea that there is a tension between the confidentiality that parties expect in arbitration and that an arbitrator doing something wrong should somehow benefit from that confidentiality. I think if arbitrators are held liable for acts of bad faith, misconduct, choose whatever term you want, we should know about it because parties are appointing and they need to appoint with their eyes and ears open. But I do accept that just because an arbitrator has had allegations raised against them, it shouldn't be presupposed that those allegations are going to be well-founded. So what we do in my jurisdiction, which might be an approach, is the default position is that arbitration-related claims, which will include award challenges, removals of arbitrators, and in this case, questions as to the arbitrator's immunity, they are held in private by default. So if you look through English case law and judgments in an arbitral context, you'll often see what we call the alphabet soup decisions, because it's A versus B, P versus Q, etc. It's a nightmare when it comes to citing authorities. And the parties don't, the public doesn't know who the parties are, but then the judge has a discretion to allow the matter to be heard in public, alternatively to allow the anonymization of the parties to be removed in the judgment, where in essence they feel it is appropriate to do so. And generally that arises in two circumstances. One, if there is essentially bad conduct on the part of the arbitrator, and so there is a public interest in the name being disclosed, or there is some reason why anonymity needs to be removed to allow the precedential value of the judgment to take hold. So that is how we deal with it. And I think that probably does strike quite a nice balance because it avoids parties simply using litigation to impugn the name of an arbitrator to put them under pressure, because of course the name of the arbitrator won't ever be disclosed.
Thank you. And Shola, do you want to add anything?
Oh, yes. I was reading through the question.
We'll
Come to question.
Do you
Okay.
wanna add anything on balance, or can we go on to the question?
Yes, yes, let me add something to it. I think the other person on the table, she said something about what needs to be, yes, what should be done. And I think it's important for us to begin to take into consideration training for arbitrators. For instance, you have a number of international instruments in that regard. We have the international, the IBA Code of Ethics, and then of course there's ICA, the guidelines on standards of practice in arbitration. So I think the institutions in Nigeria, I'm talking about Nigeria now, we need to, and other institutions in Africa, we need to begin to do a lot of training in that, so that even if bad faith is an issue, and even if the bar is very high, let us as arbitrators also prepare ourselves for the difficult days ahead. That's mine.
Thank you. I just wanted to comment from Kenya. So in terms of this balance between right to fair hearing and protecting the arbitration process. So the right to fair hearing is a fundamental right in our constitution, but so is arbitration is protected in our constitution. So judges have a duty under our constitution to promote the use of ADR, and specifically it mentions arbitration, promote the use of arbitration, which means that essentially these two fundamental rights are already balanced. It doesn't mean that one right outweighs the other, because arbitration is simply a private mechanism that the parties have agreed to in advance for the resolution of their dispute. It is not somehow inferior to litigation. In fact, it's supposed to be protected and safeguarded by the courts. So that could be a good starting point to address some of the collateral attacks made in the guise of fundamental rights. Now we have some questions on the screen. I think some of the questions have already been addressed in the comments made by the speakers. But I wanted to ask the one about where you have a party that is consistently derogatory or defaming in order to frustrate the arbitrator and try to encourage the arbitrator to recuse themselves. What should that arbitrator do? And I'd like to ask Shola, what do you think an arbitrator should do where you're facing such a party or counsel?
I didn't get the question.
So the question is, how do you propose an arbitrator handles a party who has consistently been derogatory?
Well, I think, the arbitrator is a master of his proceedings, and one of the things we have said, as an arbitrator is that you need to be firm. But being firm, you have to do it gently. You tell the party that is being unruly that, look, you stop it, because you have the right to give costs for conduct that is not right. And you let the parties know that at the end of the day, depending on their conduct, you can damnify whoever has not done the right thing in cost. But then again, I guess as the arbitrator, you need to be firm.
So you wouldn't recuse yourself? The question.
No, I will not.
That's good, because I think that would encourage that.
That would be that would be giving into guerrilla tactics.
And before I go to the audience, I wanted to ask, there was a question about who would pay the cost per annum of this insurance that people have to obtain. Will the parties allow it to be added to the cost of the arbitration?
I think so. I was going to say the institution should take that, should take a general professional liability insurance for arbitrators that they're appointed. But absolutely, I mean, I'm not sure if, as a party, I want that cost added to me, but, it does give some comfort to parties. So I would say, yes, parties should be able to bear the cost of that professional liability.
Here, I have to disagree with Paranami. My view as counsel is that if an arbitrator behaves properly and professionally as they should, they have no need to insure themselves against such claims. I would not be happy to pay. But I think maybe we could just take two questions on either side of the roof from the floor and then come back to Slido. There's a question.
Joseph, yeah, has a question.
Sorry? Jackie. And then there's one from this lady, Jackie, Chair of CIR Kenya. Just on this side. This side. Yeah. So go ahead, please.
Thank you very much. My name is Joseph Siaido, and I lead the arbitration practice group as Kenya Land Partners. I'm interested in hearing the thoughts of the panel regarding this subject of immunity, specifically about a scenario I was faced with as a claimant's counsel. And this was a situation where the arbitrator, on his own volition, after being appointed, and even in the appointment letter, he was notified that one of the parties has a challenge to his jurisdiction. However, after accepting the appointment and receiving that challenge, he referred the parties to courts to have that challenge resolved. So what I simply did was to write to the institution to say, look, I believe that this is bad faith. And I am inclined to now formally file a challenge asking the arbitrator to resign because I believe it's bad faith. But I want to hear what the
Sorry, was that a question or a comment? Because
As I said, I want to hear the thoughts of the panel on when an arbitrator conducts himself in a manner that is either negligent or that shows that he is not interested in the arbitration at all. And that the amount to bad faith. That's
right. Maybe Daniel, you had some very interesting definitions of bad faith. Bad faith is bad faith. Is that bad faith? I think they said something about
I feel
negligence.
like I'm giving legal advice on the stage. Joseph, just to clarify, so the challenge to jurisdiction was to the tribunal's jurisdiction generally, is that right? Okay. So in my jurisdiction, at least, there is a right for the courts of the seat, so in this case, the English courts, to determine on a preliminary basis the jurisdiction of the tribunal, where the parties agree or the arbitrator consents. So from my perspective, if an arbitrator says this challenge ought to be heard in the court for X, Y, Z reason, then that would not in and of itself amount to bad faith. Would it irritate me? Yes, a lot. Would I wish to improperly injure the arbitrator? Yes, I probably would. But I'm not sure it would meet the threshold of bad faith. But perhaps I'm conservative on that front.
Thank you. And I think we had a question there.
Yes, thank you. My name is Jacqueline Wehenya, Chair of CIAB Kenya branch. I really wanted to weigh in on the question of professional liability indemnity or insurance. And I think as arbitrators, we do need to take out this cover. And the reason I wanted to jump in, I saw the question that was asked, is because CIAB London has arranged for a cover for arbitrators. And I know they're in the process of rolling it out. Let us take advantage of this, because you don't know which jurisdiction you're going to be holding proceedings in. And if you have so many different and distinct definitions in the different jurisdictions, you just want to be careful. It's really for your own good. And what I'll say, because we had an incident in Kenya. It was before my time. I know Prof is looking at me and smiling. And I think I need to just bring this to everybody's attention, is that when we think of immunity, sometimes we think that it is absolute. It isn't in all jurisdictions. And the way also to invoke it is not automatic. And if you assume that the court knows that you have immunity, you may assume to your own detriment. So I don't know whether I want to go into the specifics, but if you take or you write a letter to a judicial officer in a different country and say that I have immunity, they will not give you immunity unless you proceed according to the rules of that jurisdiction to invoke your immunity. And if you take the wrong steps, you can take the wrong steps and find that you are afoul of the procedures in that particular jurisdiction. In our country, what happened is that an arbitrator invoked immunity through a letter. We don't approach court through a letter. You get a counsel, you get somebody to represent you, and you get them to also argue your position. They didn't do that, and they were asked to present themselves once, twice, thrice, maybe even 4 times. They didn't turn up. So what the court usually does is, I am the judicial officer. I am going to issue a warrant for your arrest. And that became very, very uncomfortable. And I know we had to step in to help that particular arbitrator in Kenya. And what I want to, the message I would like to pass on to everybody is, let us take advantage of professional indemnity, whether it is through CIAB, the global, or through CIAB Nigeria or CIAB Kenya. Please get it. And then make sure that you look for somebody in the jurisdiction that you are holding your seat, so that you can be able to comply with the rules and the regulations there. Otherwise, you could find yourself in a very uncomfortable situation. So you may be doing everything in good faith, but if bad faith is bad faith, you never know what the particulars of that bad faith are going to translate into ultimately and how it's going to affect you personally. So please get that professional indemnity cover. Thank you.
Thank you. I think there's a comment there next to you. Sorry, I just want to take a comment on that side and one at the back, and then we might be able to add parting shots. I'm not sure. There's a hand at the back and a hand at the front, please, for Mike.
Okay, I'll let her start because she's my senior.
Prof. One.
I think just to latch on to what Jackie has said, I think sometimes
It's okay. You sometimes
arbitrators forget. I think sometimes arbitrators forget that we are not judges. And that is important. And you won't believe this, but the person who actually at a conference, a working group event at University of Cambridge a few years ago, took time to remind us that we're not judges is Lord Hoffman, P&ID versus Nigeria fame. And he said to us, we must continue to remember that we are not judges. And I think that's why this example is really important. And yesterday we were told by Justice Augie that some judges feel I'm the judge. And they do have a right to feel that way. We want them to be teachable, and all of us are learning, but at the end of the day, they occupy that office. So just to remind us, don't just write a letter, and when you then get into trouble, it becomes the problem for everybody.
Thank you. And there's just one last comment at the back, and then I'm going to run the poll again, and we're going to close the session.
Thank you very much. My name is Lumala Sionis. Right. This is a very important topic, and I really thank SIAB Nigeria for including it in the program. And I am personally involved currently in a matter where I'm seeking refund in court for tribunal fees paid because the arbitrator delivered an award which he titled as final and binding. And yet it is referring parties, a construction arbitration dispute. He's referring parties to go and do valuation and get final accounts and then finalize in 6 months, ABCD. You know, sometimes if you're an arbitrator, if busy, do not delegate your work to other people because he's a reputable arbitrator and you don't expect that. So I believe it is possible in litigation to stretch that definition of bad faith to such conduct by an arbitrator. And that's why I support my chair, Jackie. We must take out professional indemnities because I'm going to win in this case against this arbitrator, who is my friend. And I'm sure also you have heard of the arbitrator who is reputable, who was made to refund part of tribunal fees because the conduct of the arbitrator in the proceedings, I don't know if you touched on that, I may have missed it earlier, was questionable, you know? And so because we know he's a reputable arbitrator, and then he was actually made to refund part of that fees in our jurisdiction, calls to mind that as arbitrators, we need to be.
Thank you, Eunice. It's just I'm running out of time, and there's a very important professor I've been told. I am not allowed, if I'm going to leave safely, to ignore. So please let us allow one more interjection.
Thank you.
And can we run the poll while that is running? We're running the poll again to see if anyone's changed their mind on immunity.
Thank you very much, Aisha, and good morning, all. I want to say those who cannot afford to take an insurance policy, I was involved in the reference where we had to draw terms of engagement. And one of the clauses is disclaimer that if we are sued, the parties will bear the cost. As though we knew, we actually sued. So we asked the parties, do we engage a counsel? They say, no, you are nominal parties, don't engage a counsel. Thank you very much.
Thank you. Thank you
Aisha,
so
can I
much.
just make one 30-second point very, very quickly?
Okay.
I hear all the arguments about professional indemnity insurance, and it's very sensible and wise. Please don't think, arbitrators, that just because you have an indemnity insurance, your qualified immunity is now absolute.
It's not.
It's not. It's not licensed to thrill. And I would encourage you, the devil is in the detail. Look at the policy. You may well find that it doesn't cover acts of bad faith.
It normally wouldn't under insurance
So
policies. Yeah.
actually, you might be buying something that isn't worth the paper it's written on. Just bear that in mind.
Yeah. No, I think and acts of criminality would definitely not be covered. I just wanted to say, when we ran the poll at the beginning of the session, there are very few people in the room. 80% of the audience were in favor of qualified immunity. 13% thought there should be no immunity at all. 7% were for absolute immunity. Now, I don't know if this is because it's Nigeria, 100% are saying qualified immunity. I think that's so interesting. Nobody's for absolute and nobody's for nil. 100%. I've never seen these are like election statistics in Kenya. When you find somebody is elected with 110% of the vote, that is Kenya. Thank you so much. Thank you. Please give a hand to my panel. Wonderful, Shola, Karanami, Daniel. Thank you so much. Thank you to the audience.
Wow. I want to right on top. I want to especially appreciate no, the one eye is not for you, it's for the next session. I want to especially appreciate our panel. Please one more time for we put our hands together for them. Very important. Thank you very much. I'd like to quickly give shout out to two very important people. First, our session coordinator, Adewale Balogun. He'll be getting the gifts already. And also, I'd like to appreciate our sponsors for this section. I'd like to appreciate Stevenson Howard. Please can we put our hands together. Please can we clap the little louder for them. We'll now take our gift presentation before the picture. And to help us do the presentation, I'd like to invite Jacqueline Ekia, is Kenya branch chair. I thought I saw branch chair of Equatorial Guinea, but it's Kenya. The panelist profile is Kenya. Not Equatorial Guinea. Why Kenya? Is it the country or the name?
Waihenya from Kenya.
Oh, Waihenya from Kenya. Oh, nice. I get it. Welcome. The profile of all the panelists is on page 39. So please, would like us to always, go through our brochure. It's a very communicating and working brochure, so we can enjoy. I'd like to invite Aisha first to take a first gift. As they come on, I think they should clap for each of them. Our very powerful moderator. Extra time, hit the nail on the head. Thank you. We appreciate you, Aisha. Yeah.
And that's slowly going.
I'd like to also invite Mr. Shola Ephraim. Mr. Shola Ephraim Oluwanuga, MNI. Okay, so thank you, Sound. Thank you. So I'll take pictures. I'd like to invite Mr. Daniel. We're trying to keep the time. Mr. Daniel. Oh, pen, okay. Oh, Perenami first. Okay. Perenami Momodu. Yeah. Okay.
Thank you. Very good.
Thank you, Perenami Momodu. I appreciate you. And then Mr. Daniel will be final. Please can we clap for Mr. Daniel? Mr. Daniel. We have opened this one before. We have done this before. So let's invite Chair No, I've opened his own before. He has been doing this interview. Yeah. Okay. So I'd like to invite Chair so we can take a picture, and the conference co-chairs so we can take a picture. Yes. Okay, our session coordinator too will also join. Invite Prof. Sir to just help us join the picture. Thank you, Professor. And the branch secretary. We also invite the branch secretary to also join this picture. Secretary, sir. Quick announcements. Okay, past chair to join. Second picture ready. Okay, sorry everyone. Sorry, let's take it again. Past chair, if she could just join us. Past chair. Mr. Dekoya, yes. Okay, she forgot she was past chair. Okay, future minister. Listen. I don't know which one I will call you, Mother. You next future vice president of Nigeria. The first female president of Nigeria. Okay, so I take quick announcements while we are. I take quick announcements. First is that there's need for, okay, one more time, can we put our hands together for them? Thank you very much. We especially appreciate everyone that's been on this panel. Thank you. Thank you. Thank you very much. Our raffle tickets. We don't want people to rush on each other during the gala nights to get raffle tickets. Raffle tickets are selling, they are on sale now. And I just realized that I went there to go and check up. I saw the sale is slow. So if we could just purchase it now before it gets to gala night, so we don't have to get to rush at that point. The gifts and the rewards are very amazing from the raffle draw we're going to do. I had there's a trip to Turkey. I've already purchased raffle tickets. Anybody who tried to say I'm not part of it, I'll take you to court. I've purchased already, Chair. I'm sure you didn't know. So please let us buy tickets, buy a raffle ticket so we can all be a part of the raffle draw. It's very important and it's very key. Thank you. My name is Chuks the General. Olisa, let's run our next